The Slaughterhouse Cases, 83 U.S. 36, 1873, was the first United States Supreme Court interpretation of the recently enacted 14th Amendment to the Constitution. It was a pivotal case in early civil rights law, reading the 14th Amendment as protecting the privileges or immunities conferred by virtue of federal, United States citizenship, to all individuals of all states within it, but not to protect the various privileges or immunities incident to citizenship of a state. However, federal rights of citizenship were at that time few, such as the right to travel between states and to use navigable rivers. The 14th Amendment did not protect the far broader range of rights covered by state citizenship. In effect, the 14th Amendment was interpreted to convey limited protection pertinent to a small minority of rights. The decision consolidated three similar cases: the Butchers' Benevolent Association of New Orleans v. the Crescent City Livestock Landing and Slaughterhouse Company, Paulus Teben, L. Ruch, J. P. Reed, W. Maley, S. Fernberg, B. Bubay, William Fagan, J. D. Broderick, N. Seibel, M. Lan, J. Gitzinger, J. P. Aycock, D. Verges, the Livestock Dealers and Butchers Association of New Orleans, and Charles Cavarook v. the State of Louisiana, Exrel. S. Belden, Attorney General. The Butchers' Benevolent Association of New Orleans v. the Crescent City Livestock Landing and Slaughterhouse Company. History and legal dispute. As one resident put it, New Orleans in the mid-19th century was plagued by intestines and portions of putrefied animal matter lodged around the drinking pipes, coming from local slaughterhouses whenever the tide from the Mississippi River was low. A mile and a half upstream from the city, 1,000 butchers gutted over 300,000 animals per year. Animal entrails, known as offal, dung, blood, and urine were a part of New Orleans' drinking water, which was implicated in cholera outbreaks among the population. Between 1832 and 1869, the city of New Orleans suffered 11 cholera outbreaks. In response, a New Orleans grand jury recommended that the slaughterhouses be moved south, but since many of the slaughterhouses were outside city limits, the grand jury's recommendations carried no weight. The city then appealed to the state legislature. As a result, in 1869, the Louisiana legislature passed an act to protect the health of the city of New Orleans, to locate the stock landings and slaughterhouses, and to incorporate the Crescent City Livestock Landing and Slaughterhouse Company, a law that allowed the city of New Orleans to create a corporation that centralized all slaughterhouse operations in the city. At the time, New York, San Francisco, Boston, Milwaukee, and Philadelphia all had similar provisions to confine butchers to areas that kept offal from contaminating the water supply. The legislature chartered a private corporation, the Crescent City Livestock Landing and Slaughterhouse Company, to run a grand slaughterhouse at the southern part of the city opposite of the Mississippi River. Crescent City was not to slaughter beef itself, but to act as a franchise corporation, renting out space to other butchers in the city for a fee under a designated maximum. In addition, the statute granted sole and exclusive privilege of conducting and carrying on the livestock landing and slaughterhouse business within the limits and privilege granted by the Act, and that all such animals shall be landed at the stock landings and slaughtered at the slaughterhouses of the company, and nowhere else. Penalties are enacted for infractions of this provision, and prices fixed for the maximum charges of the company for each steamboat and for each animal landed. This exclusivity would last for a 25-year period. All other slaughterhouses would be closed up, forcing butchers to slaughter within the operations set up by Crescent City. The statute forbade Crescent City from favoring one butcher over another by promising harsh penalties for refusal to sell space to any butcher. All animals on the premises would be inspected by an officer appointed by the governor of the state. Over 400 members of the Butchers' Benevolent Association joined together to sue to stop Crescent City's takeover of the slaughterhouse industry. In the background of his majority opinion, Supreme Court Justice Samuel Freeman Miller reiterated the concerns of the butchers. This statute is denounced not only as creating a monopoly and conferring odious and exclusive privileges upon a small number of persons at the expense of the great body of the community of New Orleans, but it is asserted that it deprives a large and meritorious class of citizens, the whole of the butchers of the city, of the right to exercise their trade, the business to which they have been trained and on which they depend for the support of themselves and their families, and that the unrestricted exercise of the business of butchering is necessary to the daily subsistence of the population of the city. The lower courts found in favor of Crescent City in all cases. 6 cases were appealed to the Supreme Court. The butchers based their claims on the due process, privileges or immunities and equal protection clauses in the 14th Amendment, ratified by the states only 5 years before the decision in 1868. Their attorney, former Supreme Court Justice John A. Campbell, who had retired due to his Confederate loyalties, was then involved in a number of cases in New Orleans designed to obstruct radical Reconstruction. Although the 14th Amendment was passed in part to protect newly freed slaves in the South, the language of Section 1 is not racially limited. Campbell was therefore able to argue for a new, broad reading of the 14th Amendment that would allow butchers of any race to sustain their lives through labor. Although the 14th Amendment was passed in part to protect newly freed slaves in the South, the language of Section 1 is not racially limited. Campbell was therefore able to argue for a new, broad reading of the 14th Amendment that would allow butchers of any race to sustain their lives through labor.